So, my name is Craig Call. I'm the director of the Utah Land Use Institute, and I've been an attorney for a long time. And I have had some experience. I've been a city council member as well as a member of the state legislature. I just thought I'd get my sordid past out before you heard it on the street corner. I also was the property rights ombudsman for 10 years, and that was a great experience. With me are Wilf Summercorn, who is among those most seasoned in the planning profession. He's old, right? He's planning director. He's been planning director for communities in Davis County and for Davis County, for Salt Lake City, and then for regional planning for Salt Lake County. And so he's very, very gifted. He's been a great help to planners and has been the APA, the American Planning Association, lead on legislative updates as the legislature grinds forth and produces new experiences for us as well as new law. On my right is Jordan Cullimore. Jordan is the lead attorney in the Ombudsman's office now, and he's been in private practice as well as now acting, in my opinion, in a great role, doing a super job as the lead attorney in the Ombudsman's office.
And he used to be a planner.
And he used to be a planner. He even was a planner. So we have...
I haven't done either half of them anywhere near as long as these guys, so...
So we have an attorney, a planner, and a planner attorney. So if you call that balance, I guess that's good. Just another little bit of introduction. The series we're working on is one that has originated with funding from the Office of the Property Rights Ombudsman. Thank you, Jordan. It's from the 1% building permit fee that's charged on all building permits in Utah, and that goes toward land use training. And this is one of the things we're able to do with that funding, so we appreciate that. As everyone who is involved either online or in person may benefit from several items of literature. One of them online under the Spring Conference webpage at utahlanduse.org is this outline. It includes the text, which is on the slides we'll show, not the pretty pictures, but the text is here, so you don't have to make that many notes. Another thing that we'll be relying on a lot is a relatively recently published book, Ground Rules, Utah Land Use Regulation. For those in the room, we provided you a complimentary copy. For those viewing online, these are available at Amazon.com. And shameless plug, we enjoy having you purchase it there. All proceeds of those sales go to the Utah Land Use Institute, which is a nonprofit. So, having said all that, we'll talk briefly about Utah land use law. Actually, we're not going to be brief at all. We're going to take 3 hours. But we will take a break in the middle, and we will see how it goes. Before we begin, though, I wanted to invite my cohorts here to philosophize for a minute, and I'm springing this question on them, first of all. That's right. Why are we doing this? These programs we're working on now are funded in part because of the legislature's interest in raising the level of public awareness about land use regulation and how this happens. I've attended recently some sessions, particularly on rules related to moderate income housing. And I wish at the very beginning we had taken a minute before starting the discussion about why we're doing this, how critical it is to have housing for individuals so people can afford to buy or even to rent an adequate home in which to enjoy their family experience. This is part of that. Land use regulation is a good thing. There have been some communities that recently read about in New York where they don't have zoning yet. And in a recent situation near Cornell University, there's a small town that raised 1,200 signatures to stop zoning from happening. I don't think you could raise 100 signatures in most cities in Utah to stop zoning from happening. Most of the time we've reached a consensus now that it is in the public's interest to plan and prepare and try to organize expectations and predictability. And those are good things. Plus, I also believe it helps us solve this housing crisis by having a deliberate process to do it. We can't regulate in Utah without taking into account how it affects moderate income housing. And so I just wanted to start why we're doing this. The world, in fact, can become a better place as we exercise our role in this land use arena in the appropriate way. Well, anybody want to take a philosophy from there?
So as Craig mentioned, I mean, a lot of the reason that we're doing this seminar, these seminars down here, is because of the housing affordability issue and the fact that the cost of housing has really skyrocketed over the last few years, so much so that people even of modest means or even better than modest means are not able to afford housing in many cases. And that's a real issue. That's a real concern. It's a multi-pronged problem. There's a lot of reasons for why that's happening, including interest rates, the cost of land, the cost of building, supply chain issues, and land use regulations. Land use regulations are part of the problem. They're not the entire problem, but they're certainly part of the problem. And so a lot of times I think it just helps for people to understand the background and the purpose behind land use regulations, what we're trying to accomplish, and how we can try to benefit the community. And one of those benefits would be having people being able to afford places to live. So that's one of the reasons I think we're doing this.
Yeah, and maybe this is a little preview of a panel I'll be sitting on tomorrow, but it's interesting how, you know, so the role that I play in the Property Rights Ombudsman's office is that we're a neutral agency that mediates disputes. So typically when we get involved, it's because there's a disagreement. We recognize at the same time, though, that most things happen without disagreement, right? Which is good. But really, when you think about it, the whole reason that local governments incorporate and establish planning commissions is so, and have land use regulations. I mean, they're not, you know, anti-land use regulations. They are land use regulations. So I think everyone would agree that property rights are valuable and property rights are important. And part of property rights is growth. And so it's important to recognize that and to establish processes and opportunities for people to use their land in useful ways, right? Which includes living and having a place to you know, raise a family, do whatever you want to do with your land. And so it's important that, you know, I read a statement that it's important that you send a signal for all parties involved that the land use process works, that it works, right? And it works to be able to allow people to do beneficial things with their land in a way that recognizes the public interest, that addresses the impacts of development, because there are real impacts to development, and it's important that those impacts are addressed, right? And that compatibility is ensured between differing land uses and things like that. But it's important to recognize that all of that entire process is for the purpose of allowing people to pursue their property rights. So.
Well, now let's talk about land use regulation. When St. George was settled, there were not many people here. Of course, we know it comes from a rich Native American tradition who never seemed to get, they didn't even have private ownership, much less land use regulation. And they got along well. Speaks well of their culture, with a few skirmishes here and there, I guess, in this area. But when the first Europeans showed up, we didn't have zoning. We didn't necessarily need it. They had a religious culture that kept them together, and some of the leaders of that setting would provide some guidance and structure. But it wasn't too long. I'm sure it goes way back into the late middle of the 18th century or 19th century, when there were New England style cities set up with the same kind of expectations that people from New England or Denmark or Norway or Sweden or England or wherever they came from had. That after time, as more people got involved and more, that we needed some kind of local government. So they did that. They created local government. And in America, we've experienced a tradition we call representative democracy. That is, all those people would elect individuals to serve together on a town board or a city council. And then they would meet and hear zoning issues. After the model ordinances were suggested by the federal government agencies in the 1920s, and most communities adopt them somewhere, Salt Lake in the 20s, but many communities into the 40s and 50s. But finally, each local government entity would not only hear land use issues, in many cases they created the government entity because they wanted to have input on land use issues. And when an issue comes up for regulation, everybody says yes and life goes on. Except occasionally all those people show up and then it changes the votes. So that means not only political friction, but sometimes legal, and that's why we get involved in talking about what the land use law is. The limits on local discretion involve federal law and state law. And by law, I don't just mean the statute book, but also the cases that judges have decided in the appellate court system, because they have embellished and extended what we started out with, the English common law, which was created case by case, a body of case law that people would read to try to predict how a court would rule on a given situation. So we are subject to those rules. We have the Bill of Rights. It doesn't come up often, but there are basic due process rights and equal protection, and of course private property rights involved in land use. We also have federal statutes like the Fair Housing Act and the Americans with Disabilities Act and such. We also have state statutes. Zoning power for local government comes through the state. Zoning enabling acts provide the opening and also some guardrails on how local governments do zoning. We have case law from the Utah appellate courts and occasionally from the federal circuit or the Court of Appeals and the Supreme Court. Then we have local ordinances. And obviously local entities have to follow their local ordinances just like everyone else. And then we have the health code, the fire code, and all those others. So there's a lot to talk about, and we're just going to cover this basic outline tonight. We talk about what's a legislative act and what's an administrative act, and then talk about specific administrative acts just to illustrate how they're handled. Talk a little bit about appeals and variances, and then opine again on land use best practices and ethics. But we'll kind of see how it goes. This is pretty fluid conversation, and so we don't mean it to be overstructured. Wilf, would you like to start us out by talking about who's involved in the land use arena and what the roles are?
Sure. So whenever we deal with land use and land use regulation and planning, we certainly are talking about the property owners, those who own the property and would like to do things with their property, and there may be rules in place that limit what they can do with their property. So they're very much involved in the land use process, and we'll come to the meetings and we'll come to talk to the individuals that are involved in all of that. In addition to the folks that own the property, we of course have then those at the city or county level that make the rules and process the applications that people then seek to and be able to do stuff with their property according to those rules. And so you have those folks at the local level that are elected or appointed to planning commissions and to other bodies, and they're very much involved in that and deal with that. We oftentimes call them the citizen planners because they are the regular folks in the community that either get elected or get appointed and then wind up having to deal with those land use issues. And then we have all of the other folks in town who are very interested sometimes in what's going on the property next door or down on the corner or just in the town in general. What do they want the town to look like? How do they want it to be? What do they want next door to their house or in their neighborhood? And so those folks get very much involved, particularly when something's proposed. When somebody wants to build something or do something on a piece of property, then those third-party folks, we call them oftentimes, those neighbors, those other citizens in the community get involved. And in the middle of all of that are the planners. We get to deal with everybody and try to help people to understand what the processes and the laws are and how things work and what can and can't and what should maybe and shouldn't be done, and usually get yelled at a lot for doing that. So those are really kind of the players that are involved in this land use process.
Super. Well, thank heavens for planners. Thank you. Okay. So it matters a lot, particularly to lawyers, and that's not necessarily a bad thing, what the difference is between a legislative act and an administrative act. They are handled differently. The decisions are made often by different people, and the way the courts review them is different. So, for example, a legislative act, well, maybe you ought to have Jordan explain the difference here and how it matters.
Yeah, so it's an important distinction to keep in mind with all land use decision making, to know which type of a decision you're making. Is it a legislative decision or is it an administrative decision? So high level overview, and we'll dig down into the nitty gritty. But essentially, legislative acts are those acts that are performed, going back to civics class, right? When you're making policy, when you're making the law. You're deciding what the rules are that are going to govern your community. So you're looking at all of the preferences of the community, what you want the policy to be. So those types of decisions are going to be your general plan, whether or not to annex, your zoning ordinance, zoning map, sometimes development agreements, and sometimes planned unit developments. And all of those, we're deciding, through representative government, what we want the rules to be that apply to our lives and to our community. And the courts look at legislative decision making and say, you know what, this isn't really a legal exercise, this is a policy making exercise, so we're largely going to stay out of it, right? We're going to let the elected representatives, the policymakers, make those types of decisions. And because of that, when a court ever looks at whether or not a legislative decision was made properly, they're applying that reasonably debatable standard, right? As long as it's reasonably debatable to be in the public interest to promote the purposes of LUDMA, then it's going to be upheld, and then it also can't be otherwise illegal to superseding laws. Now, when you get into administrative decision making, everything changes, right? Who you can listen to, what you're looking at, the standards that apply. Now we're just making decisions of applying the law to a specific application, right? So subdivisions, conditional uses, site plans, building permits, appeal authority, appeals and variances. Now you can't really consider policies and preferences and what people want their community to look like. Now we're just saying, what are the rules, how do they apply, and does the person comply, right? So you're making decisions that are based on the plain language, right? Consistent with relevant ordinances and laws. And then any factual determinations or discretionary decisions you're making, you have to support it with evidence. Not just conjecture or speculation or preferences, but with good evidence that supports the conclusion.
Super, thank you. So in the legislative arena, in all the land use questions, the issue is, if someone doesn't like a decision, was it arbitrary, capricious, or illegal? And again, that means there's a different standard depending on whether the act was legislative or whether it was administrative. So again, as Jordan said, if an ordinance could promote the general welfare, or even if it's reasonably debatable that it's in the interest of the general welfare, we will uphold it. This is also referred to as the rule of the stupid staff. That if the staff can't come up with a reason to justify a legislative act enough to get it past court review, then we need to look elsewhere for our help, because it's just virtually impossible on a policy basis to say a local legislative act was illegal. I mean, there's no question that they can be illegal if they interfere with someone's property rights amounting to a taking, or if they cross the Fair Housing Act, or don't comply with the legislature. That's the illegal part of the test. But the reasonably debatable test means, for policy reasons, the courts don't want to make land use policy. They don't want to be the planning commission. They want elected officials to do it. There's a separation of powers among the different branches of government, the judicial from the legislative, and the legislative bodies are elected. So the courts will sometimes even use the language to some plaintiff who's arguing, your remedy's at the ballot box. That's a legislative process. It's a policy. It's not you're not applying the law, you're writing it. So let's tell a story. This is Draper. Actually, where it says Draper, that's actually Sandy. This is at 114th South, is the horizontal line there. And in the middle of our photo, we have a brown patch of ground, some acres, 5 or 7 or something like that. And if one came upon that property, you can see a lot of it's not covered at the time of this ancient photograph. In the 7th East Street, there's some homes that face it. If you tried to figure out what was planned there, you'd come across this, which is 7th East Master Plan. And that master plan says this is going to convert to commercial. We expect that to happen. And so that's what everybody's expecting. That's what's happening. So Harmon's Grocery Stores buys the land and tears down the houses. Now this photo has an indication of where the issue is. Right beside the property are some people in very nice homes. They are very nice homes, and they are normally very nice people. But if you, well, let me show you a picture. This is the front of a Harmon's grocery store. Very nice. Beautiful. Little landscaping. What does the back of a Harmon's grocery store look like? Well, it's not the same. Which side is going to face the neighbors? So the neighbors are saying, we wish that wouldn't be built there. And in fact, they may have used other language to suggest that.
They always use other language.
So, I mean, by the way, all I know about this case is what I read in the terse arguments or the conclusions of the court that decided it. But I am intent on embellishing it and trying to make it sound like a bigger story because I'm hoping it'll be a little more entertaining. So bear with me, and those of you who know the story, please don't cringe every word. And what we do know for sure is a couple of things. These neighbors are next door. The planning staff recommended approval, and by the way, this required a zone change. Now we know the general plan said it's going to go commercial, but it hasn't been rezoned commercial yet. It's still residential. So Harmon's come in and asked for a zone change, and the staff said, that's a great idea. That's what we anticipate. This fits. The Planning Commission, in its wisdom, said, sure, this is a good idea. Then the City Council is hit with a certain amount of pushback by the neighbors, and in a split vote, the City Council says, no, we're not going to do it. Now, Harmon's came in with ample evidence to support. In fact, not only did they have site plans and architectural plans and all the engineering and everything else showing it might have complied completely with every regulation the city has.
And the city's plan.
And the city's plan. But they also may have said that great sucking sound you hear when we open will be the sales tax dollars from Sandy, which will just be pouring into Draper. I mean, this is a win-win, win-win, win-win-win. Everybody say yes. Well, on the Draper City Council, a majority said no. Not everybody, split vote. So this goes to the appellate courts, to the Utah appellate courts. And Harmon simply said, look, it's in the general plan. We're in compliance with all of your dreams and ambitions. So we're going to tell the court, make the city approve our plan. Who wins this case? Why does the city win? It's a legislative decision. Perfect. Turn your handy-dandy handbook, if you would, to page 30.
If you need a book, they're out on the table.
By the way, for those viewing at home, this is available. Every chapter of the book is available in its entirety at the Utah Land Use Library. So it's utahlanduse.org. Then click the library tab, and then it'll say general overview of land use on that page. And that's all the all the chapters of this book are there. Okay, so on page 30, it says, I'll be reading the indented paragraphs. That's what the court says, and lawyers indent the court's words. Harmons presented ample information to the city council that would have justified Harmon's requested change in zoning classification. However, in attacking the city's action, Harmon's burden was not to show that the city council had no reason to deny Harmon's application. Rather, the burden was on Harmon's to show that the city's decision to preserve the status quo could not promote the general welfare. Reading on. The second indented paragraph on page 31. It's a legislative body's prerogative to determine the public policy, a judicial body's job to interpret the policy, an administrative body's job to enforce the policy. Establishing zoning classifications reflects a legislative policy decision with which courts will not interfere except in the most extreme cases. Indeed, we have found no Utah case, nor a case from any other jurisdiction, in which a zoning classification was reversed on grounds that it was stupid. Now, I'm paraphrasing. It actually says arbitrary and capricious. But that's the story. So let me ask Wilf here for a second. I mean, it's in the general plan. Isn't the city bound by its general plan?
Yeah, I mean, it's in the plan. Doesn't the city have to follow its plan?
Plan's not an ordinance.
Plan is not an ordinance. In the state of Utah, general plans are considered to be discretionary. They're not mandatory. That means you can do all that work and go to all that effort to do a city plan, and then you don't have to follow it. Now, that's probably oversimplifying. That may not have been the case here. A plan is, aspirational. You're looking out into the future. And what the council may be deciding is, yeah, we want that to be commercial in the future. Maybe not just yet. Maybe it's not ready yet. Maybe we're not set for it. Or, maybe things are going to change and we're not sure that we really want to do that, at least not right now. But the basic rule in Utah is that general plans are not mandatory. They are discretionary. They're aspirational. Now, as a planner, I would say, by all means, do a plan and try to follow your plan as closely as you can, because hopefully you went through a process and you learned what all your citizens wanted, and that's reflected in the plan. But nevertheless, it's discretionary.
Thank you.
And maybe the counter argument, because I think most of the time when I talk to people, I say, yeah, especially cities, right? If you have gone through the process to come up with a general plan that is well thought out, supported by good data and those things, then you should give that a lot of weight. The counter argument is that sometimes maybe the local government didn't predict the market very well, right? A lot of jurisdictions do make general plans mandatory, which has its virtues, right? But the value of potentially making it only an advisory document is that, yeah, it becomes very persuasive, it has a lot of weight, but it also allows local communities to consider what the market bears and consider what the market thinks is the appropriate uses for things, so.
And remember, what the city said to Harmons was not, no, never. They said, no, not this plan. Not yet. Not now. So this is a picture of the sign showing Harmon's being built on that property. And this is a picture of the new Harmon store that was built there. What happened? Well, I don't know, so let's embellish it. There was an election, so there could have been a change of staff in the legislative body. And as soon as the city council changed, maybe there now, out of the 5 or 7, there were 3 or 4 who would support Harmon's plan. So they might have just brought it back and the city council votes the other way. Then if the neighbors sued, they could think, okay, well, Harmon's lost last time. Let's sue again. They'll lose again. Will they lose again? No. The city will win both times, whichever way the city wanted, because it's a policy question. Another thing you'll notice, because you're geometrically astute, or geologically astute, the Wasatch Mountains are on the side of this. The original plan was to face it onto 7th East, which would have faced the mountains. This property faces north, this Harmon store. It no longer backs on to those same property owners to the west. And if you go there today, and I need to do it, well, not today, I'd much rather be in St. George than in Draper today. But anyway, if you go there now, you'll see a series of low single-story shops facing west, and behind them is a landscape buffer that helps moderate the impact of a commercial development on the neighbors. In fact, I've often thought that if that strip of lush vegetation were in Elko, it would be a national park. I mean, it's really very, very attractive. So Harmon's could have, I know it hates me to say this because I really admire how much money was spent on lawyers to fight this case. But they might have spent it on charm school or something, I don't know. They could have done some very nice smoozing and come up with a program that people could agree, and then the city voted yes, and here we have a Harmon's. So that's the legislative process. Any thoughts more on that?
So when I was in Salt Lake City, we had a Kmart that was being converted into a Walmart, and the residents did not want that to happen. They actually wanted the Kmart to go away too, but they definitely didn't want a Walmart there. Well, Walmart has faced this kind of situation all over the country numerous times. And when the hearing came up before the Planning Commission and then the City Council, Walmart recruited a bunch of citizens from around the city who were thrilled to have another Walmart there, and they all wore these T-shirts that said yes to Walmart, and they packed the meeting. And some people spoke to me and they said, can they do that? I mean, that doesn't seem to be fair or right. And I said, this is a political process. These decisions are political. They're not legal or technical, they're political. And yes, they're very much into a political campaign because they're legislative decisions.
Thank you. Okay, so how far does that legislative discretion go? What about property rights? Well, there's a term that we could spend a few hours on. What we have are not necessarily property rights, but property expectations. The way it has evolved in the arena of property rights, there are certainly some specific rights, but most of it is the expectation that my current uses will remain and my neighbor's current uses will remain, and that's my expectation. Or if I have an upside, that I'll be able to maximize my return on investment. But that isn't the neighbor's expectation. But again, their expectations. Witness this case. This is Smith Investment. They own some property north of our Draper site in Sandy. It's an antiquated shopping center at the time our story unfolds. This is 25 years ago. And behind it is all this property. So it's owned by Smith what? Investment. You know, they are holding it thinking that their ship will come in and their dock will be ready when that happens. Well, this is an aerial photograph. Thank you, City of Sandy. But so there's like 15 acres, and the back half of it is downzoned by City of Sandy on its own initiative. They do a review. They decided that most of the commercial properties that extend deeper than 300 feet should not be zoned commercial. So they downzone the back to R2, allowing duplexes. And they look at that and say, look at all those small homes around it, that's perfect. And in today's day and age, that's the missing middle housing. This could really be good. But Smith Investment, however, they were not amused by this change. So they sued, and this went to the Court of Appeals. And Smith Investment got an appraiser, an excellent appraiser, under oath in the trial, and he said that Smith Investment's value in the property had dropped by like $500,000. Now, 25 years ago, you could have bought a house for $500,000. So this is real money. And Smith Investment showed that to the appellate court, and the appellate court said this: some people win, some people lose. It's the price we pay to live in an ordered society. In other words, to paraphrase, wah. Again, I'm just embellishing. We have a question from the audience. Just a second for the microphone.
So that property was originally zoned commercial,
Yes,
and wow.
they changed the zoning to R2. Pardon?
While Smiths owned the property. So Smiths owned the property, and then they downzoned it.
Yes, Smith bought the property when it was commercial.
Can't that be considered a taking?
No, because they still had economically viable use left. It's only a taking if they eliminate all economically viable use of the property with a zone change.
They could still build houses on it. They could still build houses on it. That's an economically viable use.
And that's what I mean when I say property expectations. The case of the major case on point, you'd say, who would come up with a rule so strict? Answer, Antonin Scalia, who wrote a case, and these are his words from the United States Supreme Court. If an economically viable use is preserved, then it's not a regulatory taking. So in other words, it's a political issue, not a legal one, on what values. And the reason is, in part, like you said, to live in an ordered society. You can't fight over every change in value. In fact, some have argued, we're getting off into philosophical dreaming here, let's have some givings instead of some takings. Because property, where did the Smiths value get its property? Because the scarcity of land zoned for commercial. In other words, it's an artificial construct by the local government that they blessed the Smiths with commercial zoning when they denied it to so many others. So it's very much a market thing, and that being the case, it's a policy thing, and that being the case, rezonings that change the value do not result in a taking so long as there's an economically viable use left. Any comment on that, Jordan, or is that it?
Sounds good.
I couldn't have said it better myself, Jordan said. We have another question from the audience.
Is this on? Okay. Sorry. So, what defines an economically viable use? If it makes 1 cent per square foot, 2 cents per square foot, or?
That's a great question, right? And that's why we have lawyers and judges, fortunately or unfortunately, right? I mean, I've seen cases, and there's cases out there, and tell me if you've seen others, but really, it's a pretty subjective question. And I mean, we've seen value decreases in 60 and 70 and 80%. And again, as long as you can do something that is economically viable, and admittedly, that's a question of fact, right? So as long as you can find through evidence and things like that, that there is some economically viable use, then you still have property that has value, and the government, through its zoning authority, hasn't taken property. You know, in our office, when people call up and ask that question, hey, has a regulatory taking occurred? Kind of the red flag that we're looking for is the local government has told me that I cannot do anything with this property. We know that's a regulatory taking, right? And then on the other side, you have all the other, you know, you can do whatever you want with your property. Somewhere there in the middle, and probably closer to here, right, is when a regulatory taking occurs. But it really depends on the facts, and to find out, you're probably going to have to go to court. So.
Although, for what it's worth, and lest everyone who is a fan of harsh property rights, you know, feel a overwhelming sense of sadness, there are some bright lines. For example, there are protected sticks in the bundle. Lawyers talk about how property ownership involves a bundle of sticks, and one of them is the right to occupy the property. Another one is the right to sell it. Well, one of those sticks might be a nonconforming use, and that nonconforming use itself is a protected property interest. An example might be a gravel pit. So if you've been operating a gravel pit, and that's the value, it doesn't matter in that narrow case that they downzoned it for housing and you could still sell it for housing. If they eliminated your protected stick, which was your existing use, then that could be a taking. And we don't want to get too deep in the weeds for that. But again, it's a little more nuanced than just the idea that they leave some value. you also have to consider the protected sticks in the bundle that might be separately protected.
Just to give you a little bit more of a sense of how complicated or nuanced this is, there was another issue in front of the U.S. Supreme Court, and the term that they used to determine whether that's an economically viable use is reasonable investment-backed expectation. Now, just what does that mean? I mean, but they, you know, they're trying to look at different ways of determining what's a reasonable value that's left on property.
And preview, we'll talk in a minute about, you know, how you can avoid this situation, right, through vested rights and things like that. So there are ways and means that you have to be able to lock the rules in place, which is useful. So.
Super, thanks. All right, so, Wilf, does this mean we can actually force that? Does this broad ability to introduce regulations means that you can tell Home Depot how to build a home or build a building in Summit County?
On what it looks like, yes. As to whether they can tell them what the home should look like in Utah, not any longer, but that's a whole nother issue. But yes, if you you can, at the local government level, you can adopt codes and ordinances that will set design standards. As Craig points out, this is, I think, a Home Depot in Summit County, and it looks different than the Home Depot we all go to. It sure looks pretty nice. And that was as a result of the code that was adopted in this particular jurisdiction. Yes, they can do that as long as they treat everybody equally and that it still allows for that reasonable use of the property and the investment to pay off. And it does. But you have to be consistent with it, and you have to treat all the same and follow the rules. Follow the rules that you have adopted. As we mentioned, and I won't get into it, but the Utah legislature a couple of years ago put some limitations on design that can be mandated at the local government level for single-family homes and two-family homes. The legislature has the ability to set rules just like your local city council has the ability to set rules, and they adopted a rule with regard to that. But yes, you can do that in your codes and ordinances.
So all kinds of regulations, how tall the walls are, or the fences are, the setback regulations. You know, you have to cover your swimming pool. You can't build a swimming pool. You can't have an ADU, an accessory dwelling unit. Or you know, I mean, all of that stuff, just general legislative initiative from local government is going to be enforceable unless it crosses some other rule by some other state or federal entity. But there's a lot of flexibility here. For example, this is a 57-acre development parcel. It says development parcel, but the current zoning when I took this picture was 1 house per 40 acres. So that's a single-family lot. However, the county involved here was interested in allowing more development, and so through the normal legislative process, they did allow development on this lot. But when the person who bought it after this picture was taken, they may have been wise to get an option instead of buying it before they knew what was going on. But there was value added by the process that the owner of the property went through after acquiring it, or as they contracted to acquire it. Because as I remember, this is now pretty much in the center of the little community of Hideout, which has a density of very nice housing on it that would make this an incredibly valuable piece of property. But again, it's through the legislative process that occurs. Okay, legislative acts. The Planning Commission always recommends for the legislative body to adopt. There's always a public hearing when legislative acts are taken, usually at the Planning Commission level. So again, it's different than administrative for that purpose. And the decisions are always made by the city council or town board or county commission. So again, this is the discretion. If it could promote the general welfare or if it's reasonably debatable, then the courts are going to uphold it, and these policy considerations are within the realm of local discretion. However, that said, that does not mean life is sweet and perfect for the city council. This is Krejci versus Saratoga Springs. In the center of this photo is a 75-acre triangle of land right next to Utah Lake, and the city zoned it for development of townhouses. Now, the density was something like 250, I forget exactly, but that's 3 units per acre, and that's not really that dense. But look, it's surrounded by individual single-family residences on a golf course. So the residents didn't like that. And they had the magic opportunity in a small community to go down to the grocery store and start gathering signatures. So they put this to referendum. And this is the case where the Utah Supreme Court ruled that a single lot rezone could even be subject to referendum. So the Supreme Court ruled this was properly before the voters voted it down, and that project was not built on this parcel. Now the developer could come back and try to find something that's more compatible, but that project was passed by the city council, one legislative body, and defeated by another legislative body, which is the politic at large. So under the state constitution, both legislative bodies are equal, the city council and the electorate, and either one can pass a statute or second guess what the other one does.
Can it go reverse?
Yes, it can go reversed. So that, as you know, we passed a law in Utah that allowed for medical marijuana. And the legislature didn't reverse it, but they massaged it. We had a law that passed from initiative that would eliminate the opportunity, a referendum on school vouchers failed some years ago, and the legislature just repassed a school voucher. So both legislative bodies can go back and forth, but it rarely happens because the will of the electorate is a very strong signal to the other legislative body. And it doesn't happen very often. But that basically means that that a legislative act can be taken to the voters. What's a legislative act? Well, this is the Cottonwood Mall site. The proposal was that Woodbury Corporation and Ivory Development would build this large, hundreds of millions of dollars project, hundreds of units of dwelling, some single family, some apartment, some townhome, some office, some commercial. The town of Holiday approved it, looked great to them. It didn't actually require a zone change because they already had a mixed-use zone. But when this went to the Utah Supreme Court, the Supreme Court ruled that because it was such a huge project in a small town, because it involved such high-level issues of policy and the future of the community, that the Utah Supreme Court ruled it to be a legislative act. So often, it's not all exactly the way it appears on its face. Ivory and Woodbury argued it's just a site plan. And the court said, well, yeah, it's a gazillion-dollar site plan, and this is the biggest issue of policy that the city's dealt with, and so we're going to let the voters have a crack at it. The voters turned it down, and now other projects are in the works, I guess, to develop that property.
It's, we've just talked about how the difference between legislative and administrative acts. And in this case, the city of Holiday had adopted an ordinance that said we have a mixed-use zone. Now, the problem was that their mixed-use zone didn't specify what uses could be in that zone, or at least not how much of each of the uses could be in that zone. And so what happened was when the proposal came in, it was a negotiation. It was a back and forth between the city and the developer saying, well, how about if we put in this much of apartments, and how about if we put in this much of this and that? And when that went to the court said, that sure smells an awful lot like a legislative action to us, because you're deciding what the different things are going to be rather than having already set those things by code or ordinance like most zoning ordinances do. And so they said, that's really more like a legislative action. Yes, it can go to a referendum.
So again, with broad brush, those are legislative acts by the city council, by the voters, broad issues of public policy. Administrative acts, however, this is the discretion. An administrative land use decision will be upheld if it is supported by substantial evidence on the record and is otherwise legal. So in the administrative setting, you have to show that the proposed development or issue, that the solution proposed by the applicant complies with the local policy decisions that were made in the legislative arena. So this isn't the time for making policy. What we're doing is just a reality check. Does this application comply with the policy questions, issues we've already resolved? If it does, we approve it. If it doesn't, then we are going to have a chance to explain why it doesn't. But in any event, it has to be supported by substantial evidence. Yes, ma'am.
Did the state legislature change the referendum rules for land use in 2023?
So moving backwards slightly, did the legislature change referendum rules, Jordan?
Let Wolf answer that.
So actually, the state legislature changed the referendum rules for land use actions in the last legislative session for transit station area plans or zoning, really, and said that if a transit station area ordinance that they had kind of specified in the code, in the state code, passes by a 2/3 majority of the council of the elected body, then it cannot be subjected to a referendum. In this session this year, another bill was proposed which would have allowed that same standard to be applied to any land use legislative action. There was a little bit of pushback from that, and so the legislature kind of modified that, and now what the bill that was passed says is that any land use legislation that passes by a unanimous vote of the governing body will not be allowed to be subject to a referendum. Transit station area regulations still just have the 2/3 majority rule, but all other land use regulations, if they're a majority or a unanimous vote, then they're not subject to referendum. I have to tell you it's on shaky legal ground, because this is based on an interpretation in the state constitution that applies to the state legislature and not specifically to local governments. But the idea was, I think, by the legislators, well, they allowed it for the legislature. It should, and we think it will apply to the local governments as well. I think, that's going to take a legal challenge to see, but it'll be interesting to see if it stands up. Many people think it won't.
Yeah, well, and that was my comment, is that from a legal standpoint, it's probably going to be challenged, and there's a really good chance that it could be overturned, because the Constitution seems pretty clear that local governments and the people have that right. So,
Well, and for what it's worth, the Supreme Court has expressed a significant interest in preserving that right of the public to vote on policy issues. So, okay, on to administrative issues. The land use decision of a land use authority is an administrative act, even if the land use authority is the legislative body. So 18 years ago, we rewrote the land use code in the state statute, and we created this term called the land use authority. And the land use authority is that entity which is appointed to act on a specific type of application. So each city might have several land use authorities. A land use authority might act on a conditional use. That might be the planning commission. A land use authority might act on some kind of special exception. That might even be the Board of Adjustment. A land use authority might act on subdivision approvals. That might be the city council, at least until the last legislative session. And now it isn't. But the different land use authorities act on different administrative decisions. So if, in fact, the city council appoints itself to be the land use authority, it must change to a different hat. It has to act as an administrative body, not as a legislative body. Now, these are, in state statute, they may be made by any entity. They may even appoint staff to make decisions on land use administrative issues with no input from either the planning commission or the city council. I mean, or the public, no public participation at all. And that shouldn't be a big surprise. For example, building permits. I mean, some of the most significant decisions we face are made by the final stamp on the plans when the project is built. And yet we don't expect the public to hold a hearing on a building permit. We've just created expectations over time in different arenas. And none of that, that's informal, it's local option, and it's not imposed in state code. So the processes are really quite open in state code for most for administrative issues, except for this legislature and the subdivision process, but that's a different point. Okay, let's talk about vested right. What's a vested right, Jordan?
So we've talked about the fact that local communities need this ability to make policy, to consider the preferences of their communities, to try to decide what the rules are that are going to govern the people, right? That's an important consideration, and it's valuable for the public interest. Kind of in competition with that, or in juxtaposition to that, is property owners also need some predictability, right? They need to know what to be able to do with their property. Or they need to know what they can do with their property when they start doing things with their property. And so that raises this question, okay, when do the rules lock in place, and when does a property owner obtain a vested right to continue to do what, or to know what the rules are that apply to the game, essentially, right? I'm going to read this. Yeah. And so that in Utah, you have different states take different approaches to the vested rights rule, right? In some states, you have to go so far as to begin to go vertical out of the ground before the local government can no longer change the rules that apply. In Utah, as an early vesting state, once you have submitted a complete land use application, as it states here, and you've paid all applicable fees, then the rules lock in place, right? So in the case of the Smith investment matter, the outcome would have been completely different, right? Had Smith Investment purchased the property and then went in and submitted their land use application to develop a grocery store prior to the local government changing the rules to R2, right? Then they would have obtained a vested right, they would have locked in place those rules, and they would have been able to build their development according to those rules, even if after that the local government came along and said, you know what, we're going to rezone this to something else. So
Okay, so there's a couple of quick exceptions to that. One of them is if there's a compelling countervailing public interest that makes it so the local government should be able to change the rules in the face of an application already filed. An example of that would be, well, for example, I live in Weber County, and in the community of Mountain Green, there was a situation some years ago, that's actually in Morgan County, where some of the homes actually started to move, and they weren't mobile homes. You know, they started to move. Everything moved but the mortgage. The mortgage stayed in place, but the house started to move. And so we had some of that in a few locations in Davis County, Layton area. So under those kind of situations where you've got a compelling public interest in not having someone build on a lot that's not geologically stable, then knowing that concern and showing by substantial evidence in the record that there is a legitimate concern, and we're talking here geologic studies, something tangible that's credible and relevant, then the city could say, okay, time out. You can't build on the lots in this area unless you give us a geologic report to show they're stable. Even though we didn't used to require that, this situation makes us do it. The other exception is a little softer, a little fuzzier. If a local government has put on the agenda an ordinance that would prohibit a development, but it hasn't been adopted yet, the local government has the option to impose that pending ordinance on a development for a 6-month period. And that, again, that seems a little funny, but this law is 40 some odd years old now. It goes way back. The court initiated it, the Utah Supreme Court. And what they're saying is the city should be able to consider changes that might really significantly affect property rights without somebody running to the building counter before we enact the ordinance. So they said if you initiate it formally and have something specific in mind, then local governments can consider that for 6 months without worrying about somebody trying to beat you to the punch. But it can only be 6 months, and the legislature this last session changed that or clarified. You can't impose a temporary land use ordinance or a moratorium and use this pending ordinance exception in sequence to delay a development for like 12 months or 18 months or something. You only get one crack at doing it right and getting the ordinances correct. But that again is an exception. So basically, vested rights means that if a person complies with the ordinances, they're entitled to approval, and the ordinances have to be interpreted the way they're written, not by somebody's wish on how they should be written. So let's talk about what that means specifically. So in the administrative arena, the land use authority, the one making the decision, must thus determine whether legally and factually the application complies with the ordinance. If it does, approve the application. If it does not, deny. In either case, explain why on the record. There has to be substantial evidence to support the decision. This is what the law of conditional uses is. Wilf, would you tell us a little bit about what this law is?
So many ordinances now have what are called conditional uses. It's evolved over the years. It really started out in the basic code as what was called special exceptions. But that's kind of evolved and it became conditional uses, and it seemed to be really discretionary, but the legislature and others said, that we really need more firm rules on this. And so what the rule is now, you can have what are permitted uses in a zone. That is, somebody has the right to go ahead and build a house or build an apartment or build a store or do something like that because it's a permitted use. But then there can also be what are called conditional uses. Under the way the state code is written now, you pretty much need to consider conditional uses to be like permitted uses, just that you can impose some additional conditions on them based on the potential impact they may have. And the rule is essentially that unless the anticipated impacts of that conditional use cannot be substantially mitigated, that doesn't mean completely eliminated, that means you just lessen the impact. If you can't do that, then you can deny a conditional use application. But otherwise, you can impose conditions so that it mitigates those impacts, and then it has to be allowed. So it's kind of it's conditional, but it's only conditional to a certain extent. You can only put rules in place to mitigate the impact, not eliminate it, mitigate it, and then it has to be allowed. Only if you really determine that there's nothing you can do to substantially mitigate that impact, only then can you turn it down. And I'll tell you, that does not happen very often.
So again, this makes sense in the context we're talking about. The policy question of whether to allow gas stations is made, and the city council knows what gas stations are. They've been there. So they knew that gas stations have deliveries from transports, for example, and that they often are open at night and that they're busy. So it's hard to come in and argue, don't allow this conditional use because they're going to bring in transports and they're open at night and they're busy. I mean, we hope they're busy. Who wants an empty, vacant gas station? They're the worst. So the policy issue set. Now the question is, okay, what can we expect in this location as the reasonably anticipated negative effects, and how do we mitigate those?
Yeah, and I think sometimes the term conditional use can be a little misleading. It should be conditioned use if there are detrimental effects that have been identified and they're mitigated according to standards in the ordinance, but that doesn't roll off the tongue as well. So the reality though is that these are permitted uses with unique impacts, right? Like we talked about at the beginning on the community, and so if you can identify those impacts and you have standards in your ordinance that act as criteria to guide the decision maker and how they can impose reasonable conditions on those impacts, then you can put conditions on it to make sure that the impacts are addressed and that compatibility is ensured.
Super, thank you. So the standards have to be in the ordinance. What are the reasonably anticipated detrimental effects? Can they be reasonably mitigated? If so, what reasonable conditions does the ordinance allow to be imposed? So, pretty simple. This is West Jordan. This is the Dannon yogurt store there, and our story is a bit stale. At the time we started here, Dannon yogurt had just opened up. And it's a lovely place. In fact, let me show you how much West Jordan loves Dannon. This is the intersection. Where Dannon is, there is prosperity. I mean, we are in really great shape. And so Dannon has this lovely campus that's been built. I thought I had that slide next. This is the campus. This is the campus. You can see all the grass there? I mean, we'd have to change that now under modern drought conditions. But Dannon is lovely, and right next to it is this outdoor construction yard. And Dannon doesn't like this a bit. But it was there before Dannon, and so they are grudgingly accepting it. But again, there's all this land around not yet developed. So Ralph Wadsworth Construction, large operation with several locations, comes in and wants to build an outdoor construction yard. And Dannon comes in. You'd expect the public clamor to come from neighbors, but from residential neighbors. In this case, you've got the city's prime commercial. I mean, the city loves Dannon. And Dannon comes in and says, do not let Ralph Wadsworth Construction build outdoor storage yard in our zone. I mean, we don't want it. Are you listening, city? If you let that happen, our relationship may curdle.
These are getting worse, Craig.
No extra charge. Okay. So turn, if you would, in your handy-dandy handbook to page, I think, about 33. This is the case of Wadsworth v. West Jordan. So what happens is the planning commission heard this, heard Dannon's concerns, and voted no, we're not going to allow the conditional use. Then it went on appeal. And in this case, the city council of West Jordan had appointed itself as the appeal authority. So they heard the appeal. And then when Wadsworth lost there, they appealed this to the Court of Appeals. And somebody asked me after one of these sessions not long ago, why don't you get some current cases? Why are your cases so old? And I said, it's Jordan Colomar's fault. Because of the Ombudsman's Office, we just don't have the kind of appellate land use cases that other states do. So thank you, Jordan.
Solve the problems, right?
Well, you didn't solve the problem at all, because how are lawyers supposed to feed their families and send their kids to school? But this is a great case, and it has been repeatedly cited, and not often do we see this. The Supreme Court cites the Court of Appeals, this case, because it's such a landmark and it so clearly states the ground. So for what it's worth. If you look on page 34, it starts a list of 4 things that the city council said were the supporting conclusions that should survive legal scrutiny. 1, the city's made a significant investment in bringing Dannon to the area, and the attributes which attracted Dannon to the area need to be maintained. Outdoor storage is detrimental to the area, making the area less attractive and injurious to the goals of the city. 2, outdoor storage may be considered to be a nuisance to neighboring property owners. 3, outdoor storage would encompass the majority of the parcel. The area and intensity of outdoor storage are much different than that of neighboring property owners. 4, outdoor storage is detrimental to the existing and future businesses in the area and is not harmonious with the goals of the city. So that's the basis for the decision. Wadsworth takes it to the Court of Appeals. Who wins this case? Wadsworth. That's the problem with old cases. Everybody knows the result already.
They're too smart.
Oh, we have a pretty smart group. That is true. Okay, so the last paragraph on page 35. The standard for reviewing and administrative decisions in Utah is that they will only be upheld if they are supported by substantial evidence of the record. This does not mean that all evidence presented to the decision makers must support the decision, or even a preponderance of the evidence must be found in favor. All that's required is the local decision makers provide some credible, factual basis for their decision and include it in the record of the proceedings. Jordan, you want to define substantial evidence for us?
Yeah, so substantial evidence is essentially some good evidence, right, in layman's terms. Essentially, you know, you look at all the different types of evidence, and there's, you know, beyond a reasonable doubt, and there's clear and convincing, and then there's a preponderance. Substantial evidence is somewhere over here. It's more than a scintilla of the evidence. So honestly, in a lot of land use cases, it comes down to a battle of the experts, right? Engineers or you know, geotechnical guys or someone, they have evidence, right, to support a conclusion. And the substantial evidence standard says that you have to have some good evidence. So admittedly, in certain circumstances, you could have two bodies of evidence that are credible and that are relevant and that are factual, but they're competing. And so what the substantial evidence standard says is the local government does have some discretion to pick which one they pick, but it does have to be substantial, it does have to be supported, and it does have to be from someone who knows what they're talking about.
Super. So substantial evidence is credible, it's independent, it's relevant, and it's enough to support a conclusion by a reasonable mind. So let's say, for example, we're trying to find out if ground is stable for development, and we've got one geotechnical expert on one side saying yes it is, and we have 9 geotechnical experts on the other side saying no it's not. What does the decision maker have to do? The answer is decide. It can go either way, as long as there's credible evidence to support the decision. Then it can go either way. And again, this is the courts, the common law, extending a lot of discretion to local government. And even the legislature in its appeals process says, as standard for appeal, the decision maker shall assume the decision is correct and only overturn it if there's no substantial evidence in the record to support it, or it's otherwise illegal. So you think this was relatively easy, which gets us back to Wadsworth. So looking at page 36, the indented language. Again, the court was not impressed by West Jordan's decision. In denying Wadsworth's application, the city council relied on the finding that the city's made a significant investment in bringing Dan into the area, and outdoor storage is detrimental to the area and injurious to the goals of the city. However, the only evidence in the record supporting this finding is the concern expressed by neighboring landowners. The record does not reveal whether the commission staff actually investigated the concerns raised at the public hearing, or why they concluded that outdoor storage on Wadsworth property, which is located in an industrial zone, would be adverse to the city's goals. How do we know what the city's goals are? Read the land use ordinance. Because it says right there in the front of the ordinance, we hereby, as city council members, raise the elevated status of our city. We glorify the future. We acknowledge the extreme wisdom of our residents. We are going to create a virtual utopia here. We are going to have nirvana. There will be no crime. There will be no dust. There will be no dirt. This is going to be the best place on earth, and that's the goal of this ordinance. And then the court would say, okay, well, those are general goals. How do we know how to put those goals into place? Read the ordinance. It says there. And if the ordinance says, by definition, outdoor storage is a good thing because we put it in the ordinance, then how is the city going to say it's adverse to the city's goals? Because the city's goals are the ordinance. What should Dannon have done if they didn't want outdoor storage in the neighborhood? They should have said to West Jordan, look, before we build this, would you please put a pending ordinance in place eliminating outdoor storage? Bingo. City wins. No problem whatsoever. Legislative act. But to tell Wadsworth that we just don't think it's a good idea doesn't work, because that's a policy question, and the policy issue is already settled. when we said it was a good idea to allow it in the ordinance. The next indented part on page 37. Similarly, the sole evidence supporting the City Council's determination that Wadsworth outdoor storage may be considered a nuisance is the concern raised by neighboring property owners regarding potential increases in rodent traffic and dust. Although the zoning ordinance authorized the City Council to deny Wadsworth's application if it was, quote, deemed a nuisance, the City Council did not find that Wadsworth storage would actually constitute a nuisance. The words are important here. What did they say? Well, it might be considered a nuisance to neighboring property owners. Is that a conclusion? Is that a finding of law that it might be something? Are we going to regulate what people can do on their property by our just impressions? Or do we need evidence? Thus, the finding was also insufficient to justify denial of the conditional use application. So there's no evidence in any of those statements. They're just restatements of why we want to build a beautiful city, but that's not the question. Again, the question is, does it comply with the ordinance? If it does, approve it. If it doesn't, then you can turn it down. Comments?
Yeah, I mean, Craig read the conclusions or the things that the city said, and when I listen to those, to me that sounds like the kind of stuff that you hear and you make your decision on whether it should be allowed in the zone or not. When you're setting up your zoning code, you know, yeah, I mean, it could be this, it could be that, so maybe we shouldn't allow it. That's great when you're establishing your code. In this case, the code already said outdoor storage is allowed. And it's a conditional use, so you can maybe put some conditions in place if you determine that there are some impacts that need to be mitigated. They never determined any impacts. As Craig just read, it said it may be deemed a nuisance. You need to throw your line in here.
Oh. See, I was going to avoid this out of the interest of freshness and not repeating old jokes, but Wilf has required me to do this. So here's the line.
It's good. It's good.
Oh. So if the city says you have to deem it a nuisance, then deem it. Deem it?
They didn't do that.
They didn't do that. Okay, so this is substantial evidence. It's evident, it's independent, relevant, and expert or otherwise credible. So the planning staff opinion is evidence. They're trained professionals. An appraiser's evidence is evidence on value. In the Smith investment case, an appraiser opined a value. Fully admissible, absolutely, more than substantial. Great evidence. We have a question over here. Just a second. Just a second.
You need to have your own mic.
Here we go.
So earlier we mentioned that we had 6 months to enact pending legislation that might affect it in the future. If a city were in this similar situation, the one you just described, could they suddenly use that rule to stop and push this off 6 months?
Yes,
Or would the court then ask when it was started? Was it started for a reason? Was it?
well,
Okay, I'm sorry. That's the way I think.
that's right. So thanks for the chance to clarify. Basically, it just would need to be this sequence. I mean, Ralph Wadsworth could come in and say, we'd like to build outdoor construction. And the city might say, well, I don't know, we're not sure that's a good idea. And Wadsworth would say, well, shoot, we'd really like to build it there. We'll bring an application over. And then the staff might pass that along, and a member of the planning commission might say, I just don't want it, so I'm going to propose an ordinance. Here's the language. Put it on the agenda for the next planning commission meeting. If Wadsworth had not filed their application in full compliance with the city rules and paid their fee, it's too late once they put it on the formal agenda as a pending ordinance. But if they wait 6 months and 1 day and don't change the ordinances, and Wadsworth filed this application during that period, then bingo. Just like the phoenix rising from the ashes, Wadsworth's application vests.
Yeah, and to that point, one thing that I'll say is trust is really important, right? When you're talking about the land use process. In that scenario that Craig just described, if that happens, there's a really good chance that the next time someone has an idea, they're not going to share it with the city until they have an application ready to submit, right? And one thing that we have found in our office is the lack of communication usually produces bad development, where a collaborative process usually produces good development. So you know, while the pending ordinance rule is there to allow to strike that balance, right, between pursuing the public interest and protecting property rights, use it judiciously and wisely, right? Especially if someone has already kind of showed their cards about what they want to do.
Thanks. That was a really good question. I appreciate the questions that have come up because they really helped us focus and reemphasize an important point.
I'll just quickly throw out another example. I'm on the planning commission in the community where I live. And there's an area where that had been zoned commercial, which allowed for gas stations for a long time. And the residents began to hear that there was a gas station that was going to come in. The residents that lived around it, all of a sudden it was like, we do not want a gas station at this location. And so the discussion got around to what can we do about this? And at one point, some of the city officials were saying, well, you could rezone the property. The applicant was just, everybody knew they were going to come in with an application at any time. And so the question was, should we hurry and get this on the agenda to talk about saying to rezone it? And the applicant actually showed up with an application, but the city officials decided not to go ahead with that because, as Jordan just indicated, they felt like that might establish a reputation for the community that would happen just what happened here. If they did that, next time people aren't going to share what they want to do in the community. They're just going to come in with an application and all of a sudden it's bingo rather than come and discuss it first. But the actual situation turned out that the applicant or the gas station owners came in with an application and filed it with the city before the city council could get this on an agenda to discuss, in which case they're now vested. Even if the city had wanted to rezone it, it would have been too late. The gas station would have been able to go ahead.
Okay, so again, we're talking about vested rights. We're talking about administrative decisions and how you have to have evidence in the record to support your conclusion, whatever it is. Is that along the lines of your question? Just a second.
I thought that the property, when does the city have the right to make a zone change versus the property owner making the zone change?
Anytime.
Anytime.
Either party can make, the neighbors, the city, anyone can go and say, let's make a zone change. But often it's not done lightly in the face of the opposition of the owner or the neighbors. It's a community. But technically, again, the courts just don't want to get involved to that extent to pick that issue. Okay, before we go to the break, I want to talk about one more case, and that is the importance of substantial evidence. This is Moab. You'll see there an extraordinarily long cul-de-sac. And at the end of that long cul-de-sac is a house owned by the McElheneys. And the McElheneys want to run a short-term rental. They want to do bed and breakfast. And it's allowed under the city ordinance. But they come in, and you can imagine, look at all the people on that cul-de-sac. Now, I'm not sure I understand exactly what the rules are, but my understanding is if you have short-term rental at the end of a cul-de-sac, those who come and rent your home might be a family. And if they are a family going to Moab, they have several different means of transport in the beautiful Red Rock. One of them are bicycles, one of them are foot, and they involve a certain motorized vehicle, which the neighbors may not exactly get excited about in a positive way at 2 a.m. in the morning. So the concern among the neighbors is we are going to have four-wheelers, ATVs up and down this road all hours of the day and night. Now, whatever happens, the neighbors came out and screamed bloody murder. And the city council denied it. And the Utah Supreme Court took this case. Now, usually land use cases are not decided by the Supreme Court. But they took this case and they said, look, where is the substantial evidence that you base your decision on? I'm hearing all kinds of policy questions about how bad this is for the neighborhood, but you, City Council, picked this use. I'm grossly paraphrasing on the analysis, but not the end of the result. You had all this list of different uses you could put in there, and all these lists of things you could say yes or no, completely legislative discretion. You chose bed and breakfast as an allowed use. You made it a conditional use, but it's allowed. So we're sending this back to you, City Council. You tell us why, in this particular zone where you've already allowed it as a conditional use, Where do you find the evidence to support the conclusion that a use that you fully understood at the time you adopted it can't be mitigated in this location?
Council. I mean, the issue here really was that the council gave no reasons. They just said no. That was it. No reasons as to why it was being turned down, and I think that was the big issue, the big problem.
So what did the council need to do as they made this decision, Jordan?
They needed to provide the evidence, right? And the courts have been really, they've emphasized that in subsequent cases since then to say, essentially, you got to show your work, local governments, right? And I think part of the reason for that is so that they go through the exercise of deciding, do we actually have good reasons, right? And do we have evidence to support our conclusions? Because if they don't, then they shouldn't be making that decision.
So how could you support the conclusion not to allow it? I don't know, but you could support some reasonable conditions. That's the point. So the neighbors who came to argue should not have argued, don't allow it. They should have said, look, we want a 8 a.m. or 8 p.m. curfew on ATVs, or we want, something, even though the legislature has restricted what local governments can do in terms of limiting OHV traffic in their cities. This is a conditional use. So in the process of the conditional use, the city could have imposed some regulations that they would expect the owner to enforce about how the people who occupy that home would handle their off-road vehicles. And that they could have done, but they couldn't turn it down. Okay? One comment.
This is actually one of the reasons why many of us in the business of land use say, don't make your elected officials the land use authority, because they're too used to acting like legislators. They don't get the administrative part, or they don't want to get the administrative part. They want to be able to react when the citizens come in and yell and scream. And they're really good at that. I mean, they got elected that way. But when they're acting as a land use authority, they need to be operating under different rules that we've been talking about here with substantial evidence and all of that other stuff. And they often don't do that because they think of themselves as legislators.
Yes, sir.
Quick, so they could have put some conditional uses on that.
Yes.
Would they have to apply that across the board, or can they single out somebody and say, you alone need to control your traffic when you don't do that to 2 streets over?
You need substantial evidence, that's all. If you can distinguish between different uses
Between
with
the two.
substantial evidence, sure.
Okay.
But we have another case we won't talk about, Uinta Mountain Ranches versus Duchesne County. And here's a situation where a small population county fought a significant battle with some funded people who wanted to put in a group home. And everybody in the neighborhood always loves a group home proposal. I mean, this is where you can send your wayward teenage boys. I'm sure you'll love that in your neighborhood. And the other people in the area said, well, maybe not as much as you think. But in that case, the Court of Appeals said, Duchesne County, you allowed one of these in this place and not in this place. If you're going to do that, at least show by substantial evidence why they're different, because otherwise it really looks arbitrary, and that's one of the key words we can't allow in our land use administrative decision making.
Also important there, right, to make sure that it's not arbitrary decision making, is that your code has objective standards that they're going off of, right? So that you can look to and it says, okay, we want to address traffic, we want to address lighting, we want to address noise and these types of things. And then you have to be able to connect the conditions that you are imposing to those standards. So as long as the law, right, the ordinance provides criteria and decision-making criteria for the decision maker to follow, and they follow those criteria and they support their decisions with evidence, then the court will say, yeah, you're good. That's not arbitrary, that's not capricious, that's appropriate.
Well, and just to wrap up, and then we're going to take a short break here for the folks in the room to at least get a little sugar to help you last the last part. I was honored to serve for 10 years as a land use hearing officer, the appeal authority for Salt Lake City. And I turned down a conditional use permit. Someone came and wanted to build a pub in an area where it was on a commercial street, but they abutted, as you know, right next to these, in an older development, almost immediate residential use, surrounded by small lot residential uses. And the police chief on the record said, this is the kind of parking experiences you're going to have. This is the kind of experience you're going to have based on our experience with other similar operations in the city, on the hours of operation and how late it's going to last. And the neighbors came in and showed pictures of parking situations similar that could be viewed objectively, showing that this really would create horrendous parking situation that just couldn't be resolved with the available street parking in the area. And based on that evidence, I concluded that the negative aspects of the use could not be mitigated, and so turned it down, and that's how it stayed.